Division bench, item 1 for hearing, admission column.
Let's come for the first slide.
No, on the last occasion, what had happened, that sentence hearing was not here. Sentencing part, that part of the judgment was not annexed. That has come. Lordship has directed a registry to bring it. That has come. It is not admitted, Lordship can admit it today.
Oh, acha. This M Das. Yes, I'm Learned Legal Aid Counsel appearing for the appellant, and Ms. S. Jahan, learned APP of the state. Jail appeal presented under 383, read with 374 to CRPC. Sentence part is flagged. This will go before single bench because 10 years.
Achha. I don't have key papers, so I didn't look.
Huh.
Oh, achha.
That's why
So
I had
let's
missed out. My brother pointed out. It will be 10 years, so it will go to a single bench.
Oh, just less than 10 years.
Huh.
10 years
No,
and above is
More than 10 years is division bench. This is 10 years.
more than 10 years is different. 10 years we go to. Not for some-
That's Legal Aid Counsel and this is Jahan AP for the state. Next para. Pursuant to the order dated 29/2023, the registry has placed the copy of judgment and order dated 38/2022 and order on sentence in sessions case number 110/2020, from which it is seen that the appellant was sentenced to undergo imprisonment for 10 years and to pay fine of ₹1,000 for offense under section 436 IPC with default stipulation. Postal. As per office note dated 2/2/2024. No, sorry, 2/2/24 by the by the registry. In terms of notification dated 17/9/2019, pairing number HC full stop Roman 11 -07 oblique 2019 oblique 61 oblique RC, comma, this appeal may be heard before the single bench next paragraph. Accordingly, in terms of the said office note dated 2/2/2022, the registry shall raise this matter before the single bench.
I'm told it was in single bench only, registry has sent it here.
Pardon me?
It was in single bench only, registry has, this is what I'm told by my learned friend.
I don't know, we can't say because there's no order of the single bench. That is one. And second is that we, last time when we saw it, the sentence was not there. And that is why we had to call for the sentence.
Not. Yes.
Item 2.
$25. Also,
What is the sentence?
25 years.
25 years. Okay. But Mr. UC Rava, counsel for the appellant. Appellant 374-2, IPC against so and so. Appellee is admitted for hearing, call for the records. Issue notice returnable on, give a date after 6 weeks. No steps is required to be taken in respect of respond number 1, as the state is represented by Ms. S. Jahal under APP for the state, who has accepted notice. The appellant shall take steps within 2 days for service of notice on the respond number 2 by registered post with AD as well as by usual process.
This is also so.
The registry shall hand over the usual process to the learned APP for service on respond number 2 through the jurisdictional Patasi Lambari police station. So in the notice, it shall be indicated that the respondent 2 may apply for for appointment of legal aid counsel in the event he is unable to support. He is unable to engage counsel of his own. Be that as it may, the court also reserves the right to appoint an amicus curiae to represent the interest of respondent 2, if so required. List on so and so.
843. Item 3.
What is the sentence?
Life imprisonment.
Life imprisonment for offense under section C0225. Mr. P. Bora, counsel for the appellant. Appeal under 374-2. read with section 382 CRPC. Second appeal admitted for hearing, call for the records. The appellant shall take steps for service of notice on respondent number 2 by registered post with AD, as well as by judicial process to be served through the jurisdictional police station. So in the earlier also, right, the officer in charge of the police station shall possibly return back the service report prior to the next date of listing. Here also same. The the jurisdictional court shall ensure that the service report is returned prior to the next date of listing. So there's an IA. IA shall be considered on service of notice on respondent 2 as well as receipt of LCR.
Hello.
This assess for APP for the state.
Item 4.
Yeah. 20 years.
Under which section?
4.
4 to POXO. POXO the first item. Mr. A.K. Hussain, counsel for the appellant. And Mr. S.H. Baral and APP for the state. His IA also same. Receive, service of notice on respondent and receipt of LCR. Yes, Mr. Kaushik. White has come for orders. No, White has come.
Oh, we made a mention.
Okay.
But may I pray for one thing? So lordship referred in matters to the mediator. So that I believe there is a scope of.
There is a scope.
There is.
That depends on what Mr. Mahanta says.
Lordship, bit of, we always.
Encourage.
Better, right?
Okay,
The meritor, like,
okay.
otherwise we'll have,
You suggest a date when they can come. This is from which place?
Nobody.
Nalbari. They want to come here and or do the mediation at Nalbari?
better,
Here.
here,
Here. Suggest a date.
we may also guide.
Suggest a date.
The first week of March. First week of March.
Second,
Give a date. Give a date. Look at the calendar and give a date. Both of you agree to a date.
second.
14th of March. 6 weeks. 14th of March.
14th of March. Okay. Heard Mr. B. Kaushik, learned counsel for the appellant, as well as Mr. M. Mahanta, learned counsel for the respondent. Next paragraph. This this matter relates to matrimonial dispute between the parties. And accordingly, the court is of the considered opinion that an attempt be made by the parties to settle their matrimonial disputes through mediation process to be undertaken under the Guwahati High Court Mediation Center. Full stop. The learned counsel for both sides have no objection to referring the matter for mediation. Full stop. Both sides have suggested that the learned counsel for both sides have suggested that the date of mediation will be fixed on 14/3/2024. Full stop. Accordingly, the mediation between the parties is fixed on 14/3/2024 at the Guwahati High Court Mediation Center at 11 o'clock in the morning. Full stop. both the learned counsel for both sides shall, this is next para, shall transmit a downloaded copy of this order to the parties, which would constitute notice to them. Next para, let this order be brought to the notice of the to the Secretary, Guwahati High Court Mediation Center. Just to enable the just to appoint a trained mediator. For the for mediation of the dispute between the parties. First, the list on 1/5/2024 for report of the learned mediator.
Item 6.
Answer has been received and paper book is also ready. Let the matter be fixed for hearing.
Okay. Both sides are represented. Mr. Munir, can we appoint you as a amicus in the matter? It's a POXO offense. Okay. So it is in the despite service of notice on respond number 2. None appears on call for this said respondent. So, as the offense relates to commission of offense under POXO Act, the court is inclined to appoint Mr. P.K. Munir, learned counsel, who is present in court today as amicus curiae in the matter. The registry shall provide a copy of the photocopy of the paper book to the learned amicus curiae to represent the interest of respondent number 2. Next, by the registry shall also reflect the name of Mr. P.K. Munir as legal as amicus curiae for respondent number 2 while listing the matter next. Next, list the matter for hearing. In the month of April 2024. April 24, we are fixing it.
Item 7 with 8.
Lordship, I am appearing for respondent number 7. So Lordship, kindly be pleased to adjourn the matter for today. Because 7.
Okay, you are appearing for respondent number 2. How much time do you need?
3 weeks.
3 weeks. You have got the memo appeal? You have received the memo appeal?
Oh, no, I have no any document. I have no any documents.
Yeah, no documents.
Your Honor, the paper book is already ready in the matter.
Huh?
Paper book is already ready in the matter. It should be given a copy to.
Paperwork is ready. Oh, yes.
No, Lordship, paper book notice.
Okay. No, paperwork has been served to the state. This is office note dated 22/5/23, served on Ms. Jahan.
Maybe Mr. Madhav Sharma has signed.
Yes, yes.
He is our office here.
Ha, ha. Okay.
Directly.
No, it's okay. M. Sharma, yes, you're right. Please check up.
PP office.
Part 2 আছে না?
The appellant and Ms. S.H. Broad and APP for the state. So Ms.
Just like it.
S.S. Saikia, Learned Counsel has entered appearance for respondent number 2. As per the registry shall provide a copy of the paperwork to the Learned Counsel for respondent number 2 within a week. So on the prayer made by Learned Counsel for respondent number 2, matter is adjourned by 3 weeks.
I am repeating some I did not select. I'm appearing as a
You are in item 7.
in items.
Okay. Mr. Akhoun. In item 7 is Akhoun, and Mr. In item 8, it is huge already. This is a common paper book?
Yes.
Okay, okay. So this after 3 weeks.
Item 9, which item 10?
There is a mistake on my part in this matter. On the last occasion, I said that I had filed my objection and I had not given a copy to him. I'll give a copy later on, I said on the last occasion, but I have found that I have not filed my objection. There's a mistake on my part. As far as I'll file my objection within 2 days or 3 days, Lordship may give me some time. Or otherwise, the paper book is ready.
No, but this is 22 matter. You do it, how much time? Within Monday, you will
By Monday.
file objection? You fix it on Wednesday then?
Lordship.
See the paper books, then respondent number 2 is also. Respondent number 2 is also there.
Uh, For Mr. S. Nawaz, counsel for the appellant. Have you filed your wakalatnama? Your business is not recorded here. Have you filed your wakalatnama? No, it's not recorded here. Oh, so your presence is recorded in, yes, yes. Okay. Uh, uh, and Mr. R. Islam, then counsel for the respondent number 2. Says Jahan and the AVP undertakes to file objection in the interlocutory application by
By 8/19.
19 to 2024. Accordingly, list the matter on 21 to 2024.
Touch. Put your time.
In this bench, I'm not passing those orders. You settle it yourself. If he refuses, then tell us. Correct?
Number 10.
Okay. Okay, in 10, Mr. S. Das, appellant, same party, sir. Okay.
Hello.
Item 11,
This is earlier medical report was very central jail center.
Yeah. Acha. Why not trust? I think you are. Central jail, please? Oh, Anil Roy. Doesn't like it, but I don't know. Anil Roy, I feel I've got it. What to Koru? Not for an Anil Roy medical certificate, another.
This.
Not it. Prostamalogy, I don't know what is this disease. Grade 4 prostate problem. Prostatomalacia has been received and being continued under the surgery department. He is under continuous catheterization since 2.5 years. This leads to on and off unavoidable urinary tract infection, which have led to stenosis and further complication. He is completely unable. He seems to be very serious.
Can't you build them? Mr. L.R. Mazumdar, learned counsel for the applicant dash appellant and Ms. S.H. Ms. S. Jahan Learned ABP for the state. Next person to order dated. 29/1/2024. The Superintendent of Central Jail, Silchar, by forwarding letter dated 8/2/2024, has forwarded the report of the medical report in respect of the applicant, who is convict number AC/2812-Anil Roy, by the medical and health officer -1 in charge, jail hospital, Central Jail Silchar. Next para. Before this para, you write this by filing this application under section 389 CRPC, the applicant dash appellant has prayed for suspension of sentence by which he was sentence by judgment and order dated 29/2022, passed by the learned special judge within bracket POXO, bracket Kachhar, Silchar, in special POXO case number 10/2016, thereby convicting the applicant under section 6 of the POXO Act and sentencing him to serve to undergo rigorous imprisonment for life and to pay fine of rupees 3,000 with default stipulation. Next, in this application, the projected age of the applicant is stated to be 71 years. Then you added the contents of the medical report is as under. The last page here. First line you will strike out, huh? That's 71 years of age in this application. You have to strike that. Next, we're taking note of the now that you say the learned APP has opposed the prayer for bail. Next, however, comma, considering the medical condition of the applicant as indicated above, the court is inclined to allow the prayer for suspension of sentence by granting bail to the applicant, namely so and so, by providing that in the event he furnishes a bail bond of rupees 1 lakh with one surety of like amount to the satisfaction of the learned special judge within bracket POCSO, Kachhar, Silchar. The applicant shall be released on bail on furnishing shall be released on bail. First of the bail is granted on the following conditions. Say that the applicant shall physically appear before the officer in charge of Silchar police station once a month within first week of English calendar month, positively and without fail. And on his appearance, the officer in charge of Silchar police station shall make entry in the general diary of the police station, and he shall report to this court in the event the applicant fails to appear before the said police station. Give other conditions also. Once a month, you'll have to report to the police station. Just indicate there, it is made clear that if the applicant fails to appear on the before the officer in charge of Silchar police station on any given calendar English calendar month, comma, the court at his discretion may cancel the bail of the applicant and take him to custody till the matters heard. In the appeal, you write, so. Now, what about service on respondent number 2? Is it made? Appeal, right? The applicant shall take first steps for service of notice on respondent number 2 by submitting written up notices before the registry of the court. First off, the registry shall process the same and hand it over to the Office of the Public Prosecutor Assam for service of notice on respondent 2 through the jurisdictional Silchar police station. So with the notice, it shall be indicated that in the event the respondent 2 is unable to engage a counsel, he may apply before the Guwahati High Court Legal Aid Committee for appointment of a legal aid counsel. Full stop. The court reserves the right to appoint amicus curiae in the matter, if so warranted. Most of the notice is made returnable on after 6 weeks. Returnable on so and so. You also say that the officer in charge of such a police station shall ensure that the service report is returned prior to the negative listing. List on 8.4.
Before,
Oh, nice.
sorry.
Item 12.
Yeah, there is some confusion, Madam, on the regarding service on respondent number 2, Madam. Kindly peruse the office note dated 13/2/2024.
Oxon.
That says, Madam, we, the appellants, Madam, we have not filed the postal Talabana. Now, my lord, kindly see the order dated 28/7/2023 by which, my lord, notice was issued. We were directed to serve a copy to the Office of the Public Prosecutor and the Office of the Public Prosecutor, my lord, they were supposed to take service through the postal the concerned station. Now, my lord, we cannot file the Talabana because we have not taken steps to the post. It is the office of the PP that has to take the post, my lord.
Our office to. Usual as well as. Oh, okay, that's it. Yeah, continue.
Checking on the records, madam, I could find the objection being filed in this case.
I've seen that.
Yes, yes, no copy has been served upon us. And the no notice also is available.
Somebody has signed it.
Yes, objection, one of my colleague has filed. Das, and Das has filed.
Some DK Sharma or someone has received it.
Ah.
Anybody in your office? No.
They don't serve
Give a
the
copy.
copy, so we cannot find it.
I don't know. He signed for A. Gayan.
He died.
No, but this is the acknowledgement.
It's not an issue, madam.
No, but still,
Yes, yes.
Maybe your clerk.
There is the confusion once arose, Malad, A guy was, another guy is also there.
Oh, acha.
A guy, probably that earlier on other occasion also it had happened.
Okay.
Let the notice be served.
Okay, give a
because
copy to him.
I'll give you a copy.
Now
Okay.
regarding the steps on the response.
Okay. Uh,
You can, no. Ignore it. Supplementary file আছে হৈছে নি? Supplementary file আছে দাদা? এইখিনিৰ মাজত? এইটো বেলেগ। নহয়, এই বেলেগকে থাকিব দাদা। এই সৰু ফাইল কেইটাৰ লগত। এই ৰাইট চাইড সৰু ফাইল কেইটাৰ লগত।
okay.
What about this code? The Deepak Nayak.
Lordship,
Deepak Nayak.
Deepak
Um,
Naik.
Service of notice under POXO Act. Find that out. It's of 2022.
I can send it.
The judgment of 2022 Division Bench. Deepak Nayak. DIPAK NAYAK. Just try to find out.
I can send it. I'm mailing it, Lordship.
He's sending you a mail.
Yes. I've mailed the judgment. Deepak Naik. Hello. I think one order in the criminal appeal is like, they have taken steps and twice it was said by registered post. That are in appeal. No, BJP. And registry was supposed to track the receipt. No, it wasn't.
Just check for a mail.
Uh,
Just check for my mail. She sent
Okay.
mail. Just give that printout.
Second. Paragraph 9 is relevant.
We intend to pass the speaking order so that this type of mistakes do not occur again. But Mr. P.K. Murin, Land Counsel for the appellant. And Ms. S. Jahanlal, AP for the state. Pursuant to seen the office note dated 13/2/2024, wherein the senior JA of the criminal appeal section has referred to non-finding of Talabana or postal Talabana by the appellant. Next, paragraph. This court by order dated 22/1/2024 had directed that the registry shall track the steps taken and after processing the notice, the same shall be handed over to the learned APP for onward service on respondent through the jurisdiction Hajur Police Station. Full stop. Full stop. In view of the judicial order of the court, the senior JA criminal appeal section ought not to have refer to non-submission of Talabana or postal Talabana. Full stop. Next, this court by order dated 23, the division bench of this court by order dated 23/6/2023 passed in criminal appeal within bracket J 40 of 2022, comma, amongst others, comma, as directed as follows. Para 9. Full stop. Next, accordingly, the office staff of the criminal appeal section shall take note of the directions contained in paragraph 9 of the hearing before referred order dated 23/6/2023 in criminal appeal within bracket J 40 of 2022 and strictly comply with the same. Next para. The registry is directed to process the steps taken by the learned counsel for the applicant dash appellant and hand it over to the office of the public prosecutor Assam for service of notice on the respondent number 2 through the jurisdictional police station, which is the Hajo police station in the district of Kamrup. Within bracket. Do we say rural now? No. Kamrup, rural? No. Kamrup. Kamrup. Acha. That is not only Kamrup. Full stop. The officer in charge of Hajo police station shall ensure that the notice is served on the respondent number 2 prior to the next returnable date and service report be returned to the court through the office of the public prosecutor Assam at Guwahati High Court. First of all, notice is made returnable on. Just add there, in the notice it shall be indicated that in the event the respondent number 2 is unable to engage a counsel, he may apply to the Guwahati High Court legal aid committee for appointment of a legal aid counsel to represent his interest. Next para. The court also reserves the right to appoint an amicus curiae in the matter to represent the interest of respondent 2, if so warranted. Next para. List on. 8. So next para. Let this order be brought to the notice of the AOJ criminal appeal section. Post of the connected interlocutory application shall be considered on service of notice of respondent 2.
Order of issuing notice. In that order, manager who is directed to take steps upon the Larit PP. Who have taken steps on Larit PP and not on the registry.
That has been clarified by my law.
Then you better file a type copy of the notice to the registry. They will have to process, give an entry number and give it to them.
That we take in record. So,
Notice of
order dated 21/2023. Please submit the notice of acceptance. And some you have to put on record.
I don't know where it has gone. Saniki. Yes, steps.
Order of 22nd January, Mara says it has been kept on record. Not
Able to locate it right now.
in the main appeal.
I thought it was a- It was a there for some people.
Wow.
You file a return of notice because we are not getting it.
Just modify that order. And the council for the applicant shall file fresh return of notices for service of notice on respond number 2. We are unable to locate it.
Or we can take fresh, my lord. Right? Because we can take. Fresh.
You take a fresh return of notices, it will be processed and then sent.
Deeply obliged.
You take within 2 days, within 2 days, steps in 2 days.
Item 13.
Yeah, please, Your Lordship. Yeah, please, Your Lordship. In this case, Lordship, my senior will appear in this case, Lordship, and he is not feeling well today, Lordship.
1914 as well.
Yes,
Well, well,
okay.
Lordship, speak well.
You may choose to modify the words because your senior is now a candidate. You don't say that he is unwell. The electorate may not like it.
Today he is available.
So modify your words. I mean, electorate may not like it. Okay, item 13. You've taken consent of the other side. Respond number 2, there are,
NJ Datta is there, we can inform.
okay. Matter is called, they are not here, okay. On the prayer made by Mr. Ayu Chaudhary, counsel for the appellant, the matter stands adjourned today. Mr. S. Jahanlal, APP for the state is present. List after 2 weeks,
Wednesday, spring.
Wednesday. Okay. Wednesday then, list on so and so, okay. Okay,
Item 14.
Here we have filed our objection, but then NCR is not here. Also,
The LCR has not come, I think.
Yes, LCA is not. Can issue reminder.
Okay. So Mr. A. Ahmed, IU Chaudhary, counsel for the appellant, and Ms. S. Jal and APP for the state. Next, the registry shall issue a fresh reminder for the LCR. List after 4 weeks awaiting receipt of LCR.
Item 15.
Please, Lordship.
Yes.
What is in this matter, the respondent number who has filed their objection, and who want to file and reply on that.
No, in bail applications, what objection you will file? Objection against objection?
Yes.
No. Don't complicate the matters.
Was filed on 3rd of February.
We'll just adjourn it. Don't file an objection to objection. Okay. Heard Miss N. Burman. And Devi, counsel.
L follow. L.
I'm sorry. L. Devi, counsel for the appellant.
No, Lordship, for
Oh,
respondent.
you are the respondent. Okay, Mr. On the prayer made by Mr. D. Deori, counsel for the appellant, the matter stands adjourned today. Ms. L. Devi, Leonard, counsel for the respondent is present.
One in.
Who is for one?
You're also there.
Okay, Ms. S. Jan for respondent number one and APP for respondent number one and Ms. L. Devi, Leonard, counsel for respondent number two are present. List after 2 weeks.
Item 16.
You got the health report?
No, Lordship, A. Bosho was supposed to bring it. I don't know whether he has a, Lordship can take it.
After
up
some
at
time,
S2 or otherwise S2. I'll tell him to come.
after some time. Just wait for the report.
Item 17.
Even delay. 2000 and odd days delay.
CGC is present? No. Oh, you are there. No. But you are the,
Here,
Ni-
Lordship, I'm here on the session judge.
no, you are appearing for the applicant. But CGC, you can request somebody to be here because notice on respondent two can be served to the CGC. He is the commandant of the CRPF battalion.
Okay, so Lordship had on the last occasion and for the delay petition, Lordship notice.
Please try to understand. We are trying to simplify things for you. Ask some CGC to be here so that they can appear, he or she can appear for the CRPF, respondent number two. Okay, it will be faster. We'll take it up after some time. Just search for some CGC and ask him to be here. He know how to be here.
Item 18.
How much delay? 196. Okay. But Miss
So again, yes.
S. is Hazarika, learned counsel for the applicant. You are appearing as legal aid counsel, learned legal aid counsel appearing for the appellant. You should notice on this application, the learned legal aid counsel is permitted to insert the provision of law under which this application is filed under her signature, which shall be done before the AOJ criminal appeal section, next part, pending amendment to the cost title. I should notice on this application for condemnation of delay of 196 days beyond the period of limitation in filing the connected appeal. No steps is required to be taken in respect of respondent number 1 as Ms. S. Jahan under APP has entered appearance and accepted notice for respondent number 1. Full stop. The learned legal aid counsel for the applicant shall take steps for service of notice on respondent number 2 by registered post with AD. Stop. In addition, set of written up notices shall be filed, which shall be processed by the registry and handed over to the office of the public prosecutor Assam for service of notice on respondent number 2 through the jurisdictional. Which police station? Morigaon. Moriani police station and the district of Jorat. Post notice is made returnable on so and so. The officer in charge of Moriani police station shall ensure that the notice is served and service report is returned to the court, the office of the public prosecutor Assam prior to the next date of listing. Next list on so and so.
8th of April.
And Ms. Hazarika, in paragraph 3 also you have not given you have left it blank. Don't do that. Just add one more line. The number of the days of delay is not mentioned in paragraph 3 of this application. First of the learned legal aid counsel shall insert shall fill in the gaps under a signature, which shall be done before the AOJ criminal appeal section. The copies, please correct it.
Supplementary item 22 for orders.
Yes, right has come.
Consideration of ideal logic for suspension of sentence and legal petition of the major.
But this is FOXO matter. I think the informant is not here. As far as service is concerned. Oh.
No, we have to receive this service report from the officer in charge of
Miss Priya had taken the
The-
steps.
Silchar police station.
Miss Priya had taken the steps, but perhaps the report is awaited.
You ask her, we'll take it up at 2 o'clock. 2 o'clock, we'll take it up. Service is not there on respond number 2.
Sorry.
Item 23 with 24.
The Lordship. Lordship, the office note dated 15 reflects that LCR has not been received in this matter.
Service is complete or respond?
No, my lord, also reflects that service upon respond number 2 AD card has not been received yet. That's 802, my lord.
You have not filed objection?
Objection.
I have. Vijay हमसे have filed, Vijay हमसे have filed.
In criminal appeal number 335, my lord, the objection.
No, I'm holding 949,
Alauddin, perhaps I have not.
Alauddin, but we don't find it there.
Lordship, Alauddin, I'll file.
Item number 24, my lord.
Just one by one. In in this IA as well as in appeal, past separate orders. In IA, you say that Mr. M. A. Chaudhary, counsel for the applicant appellant, and Mr. Jahan and APP for the state. Next. The appellant shall take steps within 2 days for service of notice on the respondent number 2 by registered post with AD as well as by usual process. Post of the usual process shall be served through the jurisdictional magistrate, and the concerned court shall ensure that the service report is returned prior to the next date of listing. The notice is made returnable on so and so. In appeal, you write, the registry shall also issue a reminder for the LCR. Next list on so and so, awaiting service of notice on respond number 2 and receipt of LCR. Now, this is 374. Achha, in the IE, right, the VP shall file objection prior to the next date of listing. Now, give the supplementary file. Supplementary file. Sorry. Yeah, also in IA. as well as Ms. Ajala ABP for the state. Next, but this introductory application shall be considered on receipt of the LCR. In the appeal, you write. But this MH only for the appellate and Ms. Ajala and ABP for the state. Next paragraph. The registry shall issue a reminder to the Chief Judicial Magistrate, Karimganj, for returning to direct his office to return notice issued by this court under memo number supplementary file. HC full stop XX 24, in fact, XXIV 24 oblique 1313 oblique criminal appeal dated 10/10/2023. Most of the registration is permitted to send the requisition through email. Next paragraph. The registration also issue a reminder in the connected criminal appeal 374 of 2023 for procuring the LCR. This LCR make it TCR, not LCR, TCR. Trial court record. Just awaiting notice and service of notice and and TCR, comma, list on. Give it 84.
Time being item 17. For order. On 7/17.
You are appearing in the matter. You see, here we have issued notice to respond number 2. Respond number 2 is the commandant of CRPF. He is the informant, commandant of CRPF. So it will be better if you appear and then take process. Because she is a legal aid counsel, it will be expedited. Ms. B. Sharma Ranade, legal aid counsel for the appellant. Also heard Ms. S. Jahan and APP for the state, as well as Mr. P.K. Mehdi, learned CGC, who is present in court today, is requested to take instructions for appearing on behalf of the informant, who was the then commandant of 125 Battalion, CRPF, Basugao. Most of the learned APP shall, the legal aid counsel shall provide a copy of the connected memo of appeal and this interlocutory application to the learned CGC to enable him to obtain instructions. How much time?
2 weeks.
4 weeks, okay. Give a date after 4 weeks, list on so and so. So objection, if any, in the interrogatory application be filed prior to the next date of listing. This LCR has come? No.
Unassigned.
Huh? So, oh, this is condemnation application. Oh, condemnation application. No, not required. No order is required. In the order will only be in the IA, not in appeal.
Yeah, fine, submitted.
There's a parted matter going on. We'll take up those series. If time permits, then we'll take up other matters.
I mean,
Huh?
I mean, my next item probably will be.
Okay, so no, we have,
Yeah,
in midst of a parted matter, we have heard it for 4 or 5 days.
Supplementary item 25 to 37 for hearing, part heard.
And Mr. Kamar, this matter is a learning process for us also.
Every day is a learning process.
No, I was thinking that I had crossed that limit, but no. Mr. Das has brought her, Mr. Das and Mr. Mishra have brought her foot down back to earth. They,
Some last week ago, I think. What's that one?
they brought her foot down to earth again.
Pleasure listening.
Huh?
It's pleasure listening also.
Yes, yes, definitely.
Actually, junior, instead of sitting in the bar, should sit in the court when there is.
Mr. Kumar, in fact, that is what I think. In fact, if I now, what you call, recollect my own career, I think I have learned more inside.
Yes.
When I had no matters, we were sitting in the sessions court, sitting in the High Court and learning in the process.
Also in the High Court, my lord, when cross examination goes on, madam, if the judge is also a participating manner, my lord, then many things can be. Yeah, also.
You see, long time back, I think you were there in that matter. That, what was that? Putul Ghosh murder case. You were there in the matter. You see, at that point of time, I was just sharing it with them. At that point of time, when I had no work, I was sitting in the court, listening to the deliberations, and I could recollect that 2014 matter now, after 10 years.
It gets connected. What
So-
was learned then and now what is coming up.
Yes,
The FSL.
and then the, no, not only that, the appeal also is now is before our board. So then I recollected what had happened, what had transpired, because I was there in one particular cross-examination of that IO from Scotland Yard.
Yeah.
So I recollected and then I could, I think I could verbatim say what had transpired.
Diary,
Huh?
pocket diary. Which is-
No, but I support what Mr. Kamar is saying. In fact, if young members of the bar can sit inside, they will have a huge learning process. Because you will not get those arguments anywhere else.
So, how selection of what to say, where to fall.
What not to say.
What not to say. And the also there's the absolute rule. But
Hmm?
the most difficult part is cross examination. What not to say, or not to ask.
You see, I recollect an incident in the cross-examination part. I had during that time, I had a brief where incidentally the client was very closely known to your senior. But he did not take the brief. The client had faith on me. So he said that once you have faith on the lawyer, you go to him only. But because of that relationship, when I was cross-examining the first witness, when I turned back, I saw senior was waiting there, watching us in the cross-examination. And then he told me that I am very closely known to this person, and therefore I was, because the CPC is now taking up CRPC, so I thought that I should watch you. And then his only comment was that the cross-examination too lengthy, but you are on the line. So you see, those seniors were phenomenal people.
Yes, absolutely. They were guiding factors. Last
He-
time I got while I was in the court of special, some matter. The judge was saying to the counsel, Mr. Counsel, you are in cross-examination, not in examination in chief. So please try to understand, you are cross-examining someone, not playing chief. So the court has to caution you. That is also why I say participatory role should be played also by the courts. Right?
So those formative years were wonderful.
Yes, that's why. Always.
All
When you look
seniors,
back down the memory lane, my lord, it's always much sweeter. At that time, it was very soft.
yes.
But now if you look back, it will become very sweeter, what we learn.
Right. Thank you, but we'll take up this matter, and if time permits, we'll take up others. Otherwise, those will be rolled over.
This Milord. Yesterday, Milord, your lordship was pertinently asked a particular question about PW 26. My humble submission was on dog identification of PW 26 of G10. So your lordship, that particular query, whether G10 was present on that day in the courtroom or not, my lord. My lord, I maintain the record of the entire proceedings of the special court, my lord. This is a. May I just? Hand over, my lord. My lord, PW 26, volume 1, part 1.
Yes.
My lord, PW 26 was examined on 29/8/2000. That my lord will find part 1, volume 1, page 231. On the particular day, Mr. Jiten was present in the court. And what specifically categorically
Which order dated
29/8/2013
29/8/2013. Yes, K.H. Jiten Singh. He's present.
was present in the court. But PW 26 said that Jiten, whom he knows is not present in the court.
Give those volumes. You show it to Mr. Das also.
Part one. Hey, the right side.
My lord, part one, volume one,
Yes.
page 231.
Mr. Das, let's see this order sheet. His copy, Mr. Singh's copy, I'm giving it to you. Part one,
Part one, volume one, my lord.
yes,
Part one, volume one, page 231.
231.
My lord. Lord, it was on 29/8/2013. Lord, page 232. The relevant portion, Lord, will find in page 232.
232.
Yeah. The second paragraph, sometime 2011, 1, 2, 3, 4, 5, 6, 7, 8, 8 line, my lord. In the second paragraph, I can identify Ranjit and Jitin, but I have not seen them in the courtroom. Therefore, the Jitin who was present in the court on 29/8/2013 is not the Jitin EW 26 is referring to.
Yes.
No, my lord. Part one, volume two, PW 57, he also referred one Jitin, my lord, that I too have received that particular page 333. My lord, part one, volume two,
No, just a moment. There's a issue here.
my lord.
Uh, this, we'll come to it. We'll show you. Where is the examination of this Jiten Singh 313?
313. In part one, volume four,
Part one, volume 4.
relevant page will be page 761.
He is accused 14. No, 10. Accused 10. Accused 10.
Page, it starts from page 758. Below the relevant portion will be page 761, question number 13. Question number 13.
Question number 13.
So far, PW 26 is
Yes.
The question was, L. Rupert Singh has deposed that there was extortion demand from UNN Group and they used to pay the extortion demand in money immediately. He deposed it in transport, meaning he was appointed as nominee for transport of so and so. And he deposed that he had an account of so and so IUCB bank and you forced him to deposit all the amount. This, and he said, I have no idea. He said, and now this written mentioned by PW6 was not identified in no identification, even though he was present. So this detail is a different detail. If I don't, that has to go to appreciate the evidence. Question number 13. Now there is also another written Milord. That Milord, another written is also there, it is PW 57.
PW 57.
Part 1, volume 2, Milord will find in page number 333.
333.
Milord.
Here it is TH Jiten Singh.
Milord, it stays details. Now the question is, Jiten, they are trying to examine this Jiten and trying to establish that this Jiten is also me, and this Jiten is different Jiten. And PW 26 Jiten is also another Jiten, Milord. And PW 57 Jiten is different. And PW 34 Jiten of that particular police officer, he said he doesn't know him. Now the only Jiten who knows this PW 17, MC Arun, PW 17, but that particular portion was not put into explain. There are 4 PWs who said about Jiten. One is PW 17, one is PW 26, one is PW 34, and another is PW 57. So of these 4 witnesses, Milord, only MC Arun, PW 17 says that my younger sister, along with one Jiten. Milord. This particular question was not put in 313, and the defense also have not gone to deny that. But having not put the question in 313, the rule that particular PW 17 part cannot be relied upon. Because the learned special just thought that it's not incremental. All the incremental question has to be put. Then he has to be given a chance to explain. So having not put the question, this particular PW 17 portion cannot be relied upon.
What question?
In 313.
What question? What?
Anything incrementing against the accused person has to be put.
That PW 26 identify what you call
17.
17 identify you on doc.
PW said, not identify, said my sister-in-law along with one Jiten.
Oh, so who's the okay. Okay.
There's a narration, there's a narrative. However, that question was not put in 3-1. Well, the question number 10 of 3-1 is PW 7.
Question number?
Question number 10 of PW 17.
Okay. We take a break and come back.
Now, therefore, Milord has pointed out also that PW number 57 Jiten is not KH Jiten, it's TH Jiten. But there was a suspicion about this, who this Jiten is from these 4 witnesses. Apart from PW 17, PW 26, 34, and 57. Now, so for other witnesses are concerned, so for the identical Jiten is concerned, that is not me, that is a different Jiten. There's been brought on record, having not identified in a doc. He said that this is not a Jiten whom I know. Now, that is without surname, it's only Jiten. But 57 is with another surname, TI, whereas I am KH. And PW 17.
No, perhaps that inference can't be drawn. What the inference which can be drawn is only limited to that he says that I can identify him. Nobody put him the question, is he the person?
No. The
He doesn't
question
say that.
is not present. Having said that, that Jiten is not present in the court today.
No, no. He doesn't say that. He says that I can identify Jiten.
I can identify Jiten, but I have not seen him in the court today.
Oh, acha. Okay.
So when he's not seen him in the court, in spite of his presence on 29/8/2013,
Okay.
that part goes below. That's my humble submission. Miller.
Okay.
So therefore, the identity of Jiten cannot be ascertained from these witnesses. Miller.
Okay.
So they were trying to establish and ascertain that I'm a member of UNLF, apart from the email from these 4 witnesses. Now, that cannot be substituted.
Okay.
And that cannot be taken as an evidence in the eyes of no. Now, my lord. Next, I'll take my lord, M. Ivohol. His case number 812 and Apple number 145 of 2017. The last item, 37. It is item number 37. Criminal appeal number 145.
Ibrahim.
Ibohol, M. Ibohol. When he has some more than 7.5 years of sentence. My lord, I don't need to take your lordship to again the judgment part. He was also convicted under section 20, 121A
Just a moment.
and 80.
Convicted under section 20.
18 and 121A. Seven years under 20, 8 years under 18, and 120 and 10 years under 121A.
He has now been released.
Now, after serving 7.5 years behind your sentence of 7.5 years, he has been released on bail.
Okay.
Now, my lord, the only thing which they are trying to establish my case so far Ivohol is concerned, that I stayed in Guwahati and I was arrested on 19/8/2010 in the Nunmati case number, along with other accused persons.
He was arrested on
19/8/2010. In connection with the Nunmati case, thereafter this particular case was handed over to NIA. And since 19/8/2010, they have been languishing behind the bar and was released only in the year 2017, January. Almost all the accused were released in 2017 on different dates in the month of January.
in January
Most-
2017,
2017.
they are released.
Serving about 7.5 years, more than 7 and 8 months. Well, look, I have tried to collect information actually when actually they are released from jail, because Manipur now everything is scattered. So at least next when I'm planning to submit a chart also along with the witnesses column emails where they have relied, along with the term, the period which where I have language behind. Now, PW 53 and they are relying on PW 53 and 74. Now, even I don't need to take your lordship to other evidence. PW 53, 54 says all about email. They are the one who retrieved these emails and who has given the 65D certificate. In this particular emails, Milord, what my learned senior has pointed out in exhibit 5 to where
BW 53 and
74, they are the person who has retrieved the emails from accused 18 and 19. And PW 44, who has compared the photos which were downloaded from the emails.
BW 44.
PW 44. PW 53, PW 74 and 44, they are all the scientific officers who downloaded, who compared the photos.
Downloaded from that email.
Only from the emails. The email series of 115, well, not just summing up the argument. So now only the email, my name was there that I've been arrested along with them, along so and so, so and so. Well, that is what they are like. Now, apart from this email, nothing is against me. Except that I was arrested on 19/8/2010 from Kolkata. The part 2, volume 1, paper book. Part 2, volume 1. Part 2, volume 1. Page number 17 first. I'll take Milord to page number 17. Exhibit is 5.
Page 17.
Page 17. Exhibit 5. It is email 79. Email. E means email.
Okay.
In 79, but exhibit is 5. Exhibit is 5. Now, my name is in major category, major, lieutenant colonel and major. Serial number 7 is Ibohot. Mutung number Elias Ibohot. Now, even in the similar, I should be fair enough to say that even in the particular list, case number 18 also is there in Lieutenant Colonel group. Serial number 7. Serial number 7.
Yes.
Case number 8. And for Ibohol, it is serial number 7 in the major group. One is in Lieutenant Colonel group. Case 10, Pomba.
Yes.
Milord. Now, Milord, this is E792 that they are relying this email 792, which is exhibit 5.
Yes.
My lord, now. Now, this, from this list, my lord, they are also giving some photos. But at least, in the list I have given, I don't find my name in the photo. Now, just because in the list, which they have retrieved from the emails of 18 and 19, as per the discourse, they said, these are the names that my name is Major Ibogan. I'm Lieutenant Colonel Jit. I'm Captain so and so. So this is a list which they are basing that we are the members of UNL. No, let's assume for the time being, these are, let's assume. Not or what basis this can be made admissible, my learned seniors, your lordship for doing this. The particular embargo, to make it admissible, the first they have to qualify under 65B4. The qualification, the criteria of 65B4 cannot be complied with, that's a mandatory provision. Now, having not complied with, how can this be like that? My lord, I respectfully take your lordship to part 2, volume 5. That would find page number 1119, 1119.
Yes.
Now, 119, this is exhibit 204 million. It is 204. My lord, now this particular, in this particular examination report, my lord. This is the examination report of DP Camp 1.
Yes.
Now it says subject so and so, so and so, through so and so, so and so. Now, if your lordship goes to page 1121, 1122, these are the photos, my lord. In page 1121, they said Major Mutum Ipohol. This is now another is Lorem Jati Road. I'll be, and it's also one of the issues. And so and so some photographs are given. And they said that these are the photos of so and so. Now, my lord, the parcel one and parcel two. My lord, in 119, my lord, I'll take your dorsal to the parcel one, parcel two. The parcel one is having two sheets containing 6 photographs of the following. Now they say the photograph accused Captain Lorem Telemba, the photograph Major Mutumamba, photograph so and so. Now, the parcel containing the following sample photographs. Now, my lord, these photographs are downloaded from the email. This photograph was from the email, which they have taken or printed. Now, again, the simple photograph that is to be compared with. Now, it is downloaded from the email. One, my photograph has been taken from the custody. Now it is compared. That is what they say. But my, again, humble submission is, it is only the examination report, which has been sent by Ganwar. The sample photograph had not been exhibited before the court again. I was going through, I could not find. I was going through the whole month. And so far my knowledge goes, I think it was not exhibited. The sample photographs. One photograph from email, one photograph was taken while I was in custody. They are comparing these two photographs, my lord. One photograph email is not admissible, however, but this particular sample photograph of mine is also not exhibited. It's only on the report that this is compared, that material objects, the photograph which was taken by Nia, when it was taken, how it was taken, or how it was exhibited, that is also not on the record. And this is the basis, my lord. Even though email is not acceptable, again, they have faulted me even to compare the samples. It is only in paper that they say it happens so and so. It's only the report.
I can give you another example. I'm good in giving bad examples, and this is worse. You see, I have never seen Goddess Saraswati. But 2 days back, when in the High Court there was a puja celebrated, I came here and paid obeisance. So even without looking at the photograph, one can still come to the conclusion that the image to which I paid obeisance was
Goddess Saraswati is beyond our imagination. Beyond our imagination. It can be in any form at all.
but not this
But not in a
apparel.
criminal matter like this. But I'll be penalized for 8 years. But 10 years.
Okay.
My lord, we are Hindus, my lord. Only we pray the god and goddess only after we take birth. Sometimes even without taking birth, even in the bed, we pray them, my lord. That is what the purity needs about the god and goddess. Here, what they want to prove is only the email. And the mode of taking photograph in the custody, again, not exhibited. They might have compared, but having not exhibited the material objects before the court, how can it be taken as a evidence to substantiate their case? My lord, I respectfully take my lord to PW 44, Mr. Gangwar, that my lord will find in part 1, volume 2. My lord, part 1, volume 2. Page 276. My lord. PW 44,
Oh, PW 44.
page number 276. Hello. Today I have appeared before the court on the civil summons. I'm an MSc physicist from Bareilly University in the year 1990. Thereafter, in December 91, I joined CFSL CBI in New Delhi and worked here up to November 1995. In the second capacity, I was assisting senior official in exams of prime exhibits like sewing plant, tool marks. After that, by the selection of PC, I joined senior so. Look, on 12/11/2010, SB Nia New Delhi sent a letter regarding exemption exhibits calling open year 2 by the said letter 6% seal with the seal of censure. Exhibit 19 so are the details of where the cameras and satellite phone are in working condition. All the content of camera, including video files, are required to be recovered. All the details for incoming and outgoing satellite phone may please be provided. All deleted file may please be retrieved. The content list satellite phone may please be provided. All the deleted that may be please recovered. Any other data relevant to the above may please be provided. After receiving the articles, I examined the said articles by applying techniques like forensic data recovery system, and thereafter I have prepared my report. Exhibit 98 is a set report in 3 so and so. Now, after completing report, the director sent a letter to SP Nia Delhi for collection of the opinion and so and so, and it is mine. The details of which I examined are mentioned. It contained one digital camera with GB CyberShot model so and so, memory stick so and so. It contained digital camera so and so. It contained one satellite phone so and so, so and so. It contained one digital camera Sony so and so. One digital camera Nikon model of so and so. 35 CDs and DVDs of different Mac, which it contained the following exhibits: one handycam, so and so, one digital camera, so and so, results of examination, everything. Now, results of the examination he has given in detail. Now, the contents of details exhibit at the satellite phone was found empty. The exhibits you want to see contain different software, songs, movies, and album, etc. Now, after examination of the parcel containing exhibits sealed with the seal impression today, I have seen R1 Sony digital camera along with memory stick, which I have examined, which exhibited as material exhibit so and so, along with memory stick, which I have examined and so and so, a satellite phone along with battery, which I have examined. This. Now, what he said in his cross melod, that melod will find in page 281. 281. The last paragraph. There was a further course, because he was again further examined because they miss out something. The methodology of or the techniques applied by me The methodology or the techniques applied by me in the comparison of the photographs are mentioned in paragraph 9 of my report exhibit so and so. The seal cover of so and so containing photographs open only today. The permission to code for the first time. Similarly, the seal packet exhibit so and so DVD was prepared first time before this code. As I'm a civil expert, as said, I'm not aware if the material objects examined by me are incriminating or not. As investigating agency had not asked for the examination of the same. I cannot say whether DVD sent to the service will continue to soft copies of emails have been tampered or edited. I say that before making the CDs, tampering is possible in the soft copies. Question of tampering, he says, is possible. Now, the first, it is not the case that a photograph was taken, verified and sent. The hard, that
That part of the evidence is incorrect. That part of the evidence is incorrect. Last part in the cross section, I say that before making CDs, tampering is possible in soft copies.
Hello.
You see, this is a partial reflection and therefore false. I will tell you why. You see, you work on any computer software. It gives you a timeline of its updations. So supposing you give there's a email which is purportedly say 1st of January 2014. You tamper that today, it will give you a different timeline. It's a photograph. You crop up the photograph or you alter that photograph, it will give you a different timeline. Correct. Now I'll tell you something more. This is with some experience we had in our training programs. You see, let us say that today, as I am live, the photograph or the video of the court proceedings is taken and it is transmitted by someone to you. You take that clip and transmit it to Mr. Ashekar. You do it. Now everything will give a different timeline. So it's not that a photograph which is cropped and then transmitted will give the same description in the photograph details. It will change. It will alter. A photograph taken by your mobile will also indicate the place, latitude, longitude from where it is taken and uploaded. It will also give the details of the camera used for taking of that photograph. So in a digital world, it is not that you don't have a footprint. You will always have a footprint. And therefore, this part of the cross-examination.
Time in that time, two different manner, I can change the time. I can change it. Because one is automated. I buy a mobile and this is automated. I can change the timing of my mobile.
No. Changing of the time of your mobile will not be acceptable. You see, you just try to do it in your home when you are free. Take a photograph, then transfer it to a phone, change the timeline and the receipt, and then you send it back. You'll find that there will be a mismatch. Because the original photograph is taken on 1/1/2014. Now you do a cropping up and then you retransmit it by giving your mobile a back date. Supposing you want to make it 31/12/2013, there'll be a mismatch. It won't match. It would not be acceptable.
Not that taking civil to be very fair, but
because you see, the original photograph has a timeline. You can't put it back.
Editing thing can be.
No, editing can be done. I'm not saying no, but it's a partial. That's why I'm saying it's a partial statement, and therefore incorrect.
The expert has said, expert has said. It's not me who said. The expert has said. Because just because he's expert They have trusted him and everything was sent to him. And the expert whom they trust has said that editing can be done, tempering can be done. But it's not me who said it, it's expert who said it.
No. That's what we are pointing out, Mr. Singh. You see, tampering can be done. And whether tampering in this case was done, they are two different questions. Tampering can be done. There's no doubt tampering cannot be done. It can be done. But the pertinent question would be in this case whether that has been done. Well, it's okay. It's not the point. We
Now-
take
now,
note of your
So
submissions.
therefore, this particular photos, which they have compared, downloaded from the emails. Now, the downloaded photos from the emails, which are not admissible, my photos are taken through their camera. When I was in custody, they said it's a comparison. They compared and the photos are said. That is what they want to say. But now, to compare that photo, which are not admissible, I'm arrested, I'm behind the bar, my photos can be taken. I volunteered myself that you can take my photo. Now, with something which are not admissible, that it will be compared with something which is not admissible. Now, the first criteria is whether my photograph taken today, when I was behind a bar, can be compared with something which is not tenable in the eyes of law. The photograph which they've retrieved, they say from the emails, is it has not qualified the criteria of 65B4. That cannot be improved by comparing a photograph taken today. And okay, if that photograph by the express is matching, whether that can subside, that whether that can overcome 65B4. That is a pertinent question. My lord. This photograph which I have just referred, my lord will find in part 2, volume 1. Exhibit 18, that my lord will find page number 102A. One zero two A, Exhibit 18, Paper Book Part 2, Volume 1.
So he, that's the provide video allowed.
102A. My lord, this is E92, email 92.
They're putting as
Now sending two files, biodata is photo of the cadres. Another thing, please send friend Lixo and Sosun. Now, my lord, sending to biodata is photo of the cadres. If my lord, kindly go to my lord, if your lord sees, please, my lord, page number 113. This is E9214, email. This is the photo which I have just shown to your lordship. What a comparison. I'm in cell number should be 127. One 27, so and so. Minute page 113.
Three. Yes.
113, I'm the stove. It says 127 Major Mutum number. The next is 134, the next is 147. And what indicates this 1, 2, 3, 4, also we don't know. It says 127, then thereafter 120, 134 comes, then 147 comes. And we are not aware of this serial number also. Now, this is the photo. Now, my lord, if we compare exhibit 18 and exhibit 204.
Which page?
Exhibit 113
And
and part 2, volume 5 is 1121.
part 2, volume 5.
Volume 5. So this is the same photo which they have sent to FSL.
Yes. Okay.
I'm just trying to draw the attention to your lordship that this is the photograph of email. Which
Yes.
they're trying to compare. The same photo, the same set of photo they have taken or they have sent. This is an email photograph.
Okay. Email photo cropped up separately.
No, my lord, this is retrieved from email, page 113, my lord.
Yes.
113,
Is the same photograph as volume 5,
the same photograph in volume 5,
page 1119.
page 113 and 1121 of volume 5.
1121. Okay.
The same photograph. My humble submission is, my lord, I have been arrested. They said they have retrieved some emails. Then my photograph was there. That's what they said. They have not made any other corroboration except with the email. Except with the email. They have not even established from other sources, from other circumstances, that I'm a member of UNN. They are relying heavily only on emails, and even to compare, they have sent the photographs of email. Now, when email is not acceptable, but my humble submission, when this particular trial was going on, and when this argument was done, that Basir and all these things, Anwar and Navjot Sindhu, there was some conflict of decisions of the Supreme Court. Navjot Sindhu, they have relied entirely on Navjot Sindhu about the 65B4. You are right here to prove that you overcome 65B4. But again, that particular Navjot Sindhu has gone. They were heavily relying at that time when this argument took place in the year 2016. Now, the latest Supreme Court judgment is for any digital documents or electronic evidence or electronic documents, simply it cannot be an except 65B4. It is a mandatory provision. Now, so for PW 74 and 53, they are the one who issued certificate under 65B4, the incomplete certificate, which is not admissible. So in 2016, my lord, when these particular issues were raised before the trial court, that was something like Navjot Sandhu was that particular, the portion of the Anwar. The Anwar, the writer of Anwar was slightly, Supreme Court has given a different opinion. But when Pandit Rao came, everything has been over. That is coming 2021. But at that time, when the parliamentary that thing, even in West Bengal, because of the 65% leniency was given the law. But here in this case, no corroboration, not even a single, yesterday also I submitted, not even a single weapon was seized. No incriminating things were recovered. Everything was from the email. That some funds were transferred. Now,
That's all in this matter.
Hello?
Anything more in this matter?
no, only one case that I'll find out that I think hardly another 15 minutes.
Okay.
Because otherwise it's all sent, all evidence are sent.
Okay.
Everything is on email. And edges have to at least give 2-3 witnesses, edges. Yes. Maximum, I'll take 30 minutes.
Okay. No, time is not a constraint, but I'm just asking.
Edges is also email.
Can see prostrate properly. Here also the same, Lordship can see the status report. Here, a grade 3 it is, I don't know whether it's cancerous or what. Lordship will see his status report on 6th of February 24 it was there. Acute retention of urine with fever. He was admitted in BCH. And then impression is whole abdomen UCG, ultrasound is done. Prostatomegaly grade 3. From BCH, he was referred to FAMCH for better. Yes, he was advised to consult urology in GMC. Then he was referred to GMC, treatment in GMC given. He was advised to attend urology OPD. He went to urology OPD, GMC, treatment given. He attended psychiatry OPD in GMC, treatment given, and it's going on. It's a known case of hypertension, but. And he is aged 78 years. बेटा हुसैन है, कोई बात नहीं।
You'll have to direct the jail superintendent to send the original medical documents, because this is If they have the medical documents, they will send it by the making a report.
They have made a report. I don't know what was,
And they have
What
introduced something
letter?
which is not even the complaint in that report.
Huh.
Now they have introduced that he has been sent to psychiatry department. No,
and he's saying hypertension. I don't know what Mr. Bosho has written, wrote in the letter.
Last program, medical status report was called.
no, I understand, but there is something which has been introduced newly.
Fine.
There's nowhere it has come out that he is psychiatrically, he is having any problem. So these are,
Yeah,
once we send people to medical, then new things crop up.
And what has happened, my instruction is that the condition is very serious, madam, and what he is doing.
No, condition is not serious. It is prostate grade 3.
Fine.
In allopathic, they will operate it, but the doctors have not operated. Reason we don't know why. That is one. In another branch of medical, there is a treatment of grade 3.
treatment is given, it is said. Apart from that, he was also sent to psychiatry. This is what. আজিও অলপ আগত এটা বিল দিছে এইটো কিন্তু জানা মেটাৰ একে একে আছিল
We'll ask the jail authorities to send us the original medical documents.
This the prescriptions and all. Oh, ultrasound reports and everything.
But this is something which I can read.
Yes.
So I am more comfortable with the original medical prescriptions than a report.
He has annexed few prescriptions and all, but then he has annexed in his eye.
Where is that?
I have also, I have annexed some of the.
Where is that? I did not notice that.
But the page, IN number, the.
190. Yes.
Can I? Page 11 annexed where,
Page 11.
Am I not seeing that?
No, this is suspension. It's not here. 40,
So later on.
44.
40 or 24.
Aye.
Page 11.
Acute retention of same thing. Prostate grade 3, fever not responded. Referred to FAMCH. FAMCH আকৌ আছে. Refer to surgery.
Lord, my lord, appellant is 78 years of age, my lord. That apart, my lord, due to these diseases, my lord.
The offense is not very happy.
That is right, my lord. From the on record, the appeal is there, my lord. My lord can.
Was referred for surgery. Psychiatric lab, last or two.
Last two.
Not you, not Pandu.
Referred in psychiatry OPD after one.
No psychiatric.
আবুল তাবুল বকি থাকে তো ওটুকুলো প্রবলেম
You see, this time has come to make inquiry, to order a police inquiry into this affairs of the medical college and this doctors. You look, the doctor is now certifying
In FAMC.
no, the doctor is now certifying this prostomegally grade 3. Come to page 14. As per the UGC ultrasonography report, you see it is grade 2. Left side,
Left side. Grade,
second last, grade 2.
grade 2, ultrasound.
Sonography says grade 2.
But
and-
before that, Lordship will see grade 3, ultrasound done on 7/10,
710 is grade 3,
grade 3.
but the second ultrasound of 1212 is grade 2.
grade 2. He recovered to certain
So he's
extent.
recovering.
He is
And
recovering.
how the current certificate comes of grade 3?
This was on 12/23, so.
No, no, you
certificate-
see, it's a language of used by the Supreme Court of India. At times, mistakes can be purchased.
Uh-uh. And surgery note also, it's grade 2. And surgery note also grade 2. Page 15. GMC medical, the certificates are not there. Lordship can call for those because the one that he has annexed is only in respect of psychiatry.
No, no.
Nahani.
তাতে হেৰিও হয়
Dr. P. Sharma,
গোটেইখিনি আছে
but this is not evasive. This is very, very short and this thing. I think there are other documents.
Caption handwriting is also in
Mm.
written some
এইটো grade 3 তাৰপিছতো grade 3 পালে so grade 3 গ'ল ভাল পালে because of the medication.
One is
helpful.
Mm. Oh, but it did it. Yes. That can be. Let him be, let the authorities There can be a way out.
Can you get us the information? You see, in this page 14,
Yes.
is referred to surgery. Correct? After those parameters, BP 146 so and so, then you will find
Yes, refer to.
referred to surgery. Now, if the patient is referred to surgery, we want to know the reason why they are not doing the surgery. Number one, is it the patient who is refusing to do the surgery? Or number two, the government is not ready to do the surgery for a patient. So how will you get us that information?
There can be a way out. Let the authorities produce him before the Guwahati Medical College Hospital and we'll get the.
So why unnecessary travel? There's a medical college in Barpeta. Fakhruddin
But
Ali
he was
Ahmed.
referred to CMCH, so I'm telling. A surgery note also, they write it on the next page, page number 15.
Because government will not come and say that they have a medical college where they don't have operating facility. Surgery note, grade 2. Posthumously, the sensor. At grade 2, they will not operate.
This surgery note was before 12/12. I mean, this refer to surgery.
Grade 3 was earlier.
Grade 3 was earlier. And then the same prescription is used for different dates. At different dates. And after that, the third para on the left side, as advised from medication. As advised from medicine. Ultrasound.
Because you see, when a patient is produced before the medical college and hospital, and they advise surgery, they advise not surgery, they advise the patient to go to surgery department. And surgery department doesn't say anything. That means he's not required a surgery.
That information we don't have.
What this
But-
surgery department is required.
But-
to witness of the patient also, that whether he can go for the surgery or not. And the various tests before the surgery are also required. Generally, that will.
No, there is no advice of surgery. So question of he is being fit for surgery doesn't arise.
He was referred. And in the meantime, he recovered. It seems in the meantime, he recovered from grade 3 to he reached grade 2.
You see, I am hale and healthy, but I have some cold. So doctor will say you go to tuberculosis department. I'm just telling you, doctor says you go to tuberculosis department. I go there. But I'm not required a treatment of tuberculosis, and therefore they don't say anything. Correct?
Yes.
So merely referring me to tuberculosis department doesn't mean that I have that disease.
But considering all these aspects, it is condition of the patient is that he has some illness. At this old age stage, those illnesses might be in the jail. Cannot be getting appropriate care. So, under any conditions, there are all these.
No, the offense is not very happy.
That is a issue.
A child is arrested to be made pregnant, 5 months pregnant.
That is another issue on marriage. What has happened that pregnancy fetus was also DNA examination was done, but it does not match. That is an issue. That DNA is not conclusive.
Anyway, that is a corroborative evidence. That may not be the decisive factor. DNA not matching. But
No, DNA mismatch will negate rape.
no, Lordship, that is held to be a corroborative evidence only. But then still 376 will lie against his person. Maybe he is not the father, but he is Because this is what,
Other,
I've got so many decisions.
other evidences are also there, my lord, which indicate. that
Maybe there's some
document-
other father, but then he is involved in the incident.
My lord, the indication in the statement of the victim.
That will be very difficult to accept. If the DNA, there is a DNA mismatch.
But this is a subtle position. In fact, this mismatch is only a corroborative evidence, not a final decisive factor. Yeah, that we will go through during the merit of the case. Yeah, of course, he's 78 years old. He's quite old enough. And he has serious problems. I'll leave it to your lordship. Or lordship can get him tested again and get the latest report. Latest report, I think it is in the report itself that he has been treated in psychiatric treatment also and he is under treatment.
Jail doctor. 15. Well, this is. Very good. You get a fresh medical report by a board.
By a board.
To be constituted by the principal of Fakhruddin Ali Medical College and Hospital. We are just doing it because of the age of the petitioner. You see, I'll tell you the sequence now. As per the earlier report, he was grade 3. Subsequent report, he is grade 2. Then on 15th, he is taken to, that is a report of, grade 2 is a report of 12-12. Then on 15th, he is taken to the hospital again. In the hospital now, he does not have the problem of what you call this, prostate. Because you see that is at page 16. At 16 now he's treated for psychiatry.
These medicines are for psychiatric problem.
That's what I understand.
Coraprom, escitalopram. Because page 16 is not elaborate. I mean, nothing can be deduced.
No, it's a mild sedative.
That's it.
Cirizipam is, you'll find in the NDPS also it is there.
Acha. Also, perhaps.
It's
for
in the schedule.
psychiatric
Cirizipam is a 0.5, it's a mild sedative.
difference.
Huh. But that is given for a short duration and then it ends. The second
For
is the
seizures
drug.
and epilepsy, yes. So these medicines relates to psychiatry issues.
That's why I say I can read the prescription better than reports, medical reports.
Of the other medical reports were there.
No, you see, it's not that. It's a continuation, a medical treatment is a continuation. You are taken for problem X. Now you are diagnosed with problem Y. But there is no mention of problem X in the, and you see, this is not a, not a, what you call, small institution. It's a Guwahati Medical College and Hospital. They will not miss prostromegaly.
I'll get a latest report, that will do, not check.
So only considering the age, we are again asking for a report, otherwise I'm not satisfied with this. And you see, I work from morning 6 o'clock till night 12 o'clock. Correct. This is a normal routine. If I overshoot 12 to 12.01, I don't get a sleep. Because I miss the sleep then. Then what the doctor says is, you go to a psychiatrist, have a checkup done, and regulate your life. So going to a psychiatrist does not mean that one is mentally unsound.
There's so many issues are there.
There are hundreds and hundreds and hundreds of reasons to go there. And my reason to be referred to a psychiatrist is always that you are working more than you should. And therefore, please take a relax. You be relaxed. So that is the reason why I am referred to a psychiatrist to change my lifestyle. So merely going to a psychiatrist doesn't mean that
Not mentally.
not mentally, I become mentally unfit, not that. Heard Mr. A.R. Bhuyar and counsel for the applicant, dash appellant, and Mr. Mr. S. Jahan Rajan, APP for the state. Next para. The learned APP has produced the forwarding letter dated 6/2/2024 by the Superintendent of District Jail Abhayapuri, enclosing therewith the health status of the applicant dated 6/2/2024 by the medical and health officer -1, jail hospital Abhayapuri. Considering considering that as per the medical certificate, the applicant is 78 years of age, the court is inclined to direct the Superintendent, District Jail Abhayapuri to to produce downloaded copy of this order before the superintendent of Fakhruddin Ali Ahmed Medical College and Hospital at Barpeta, so as to enable the said authority to examine the medical papers of the applicant and constitute a board for examining the health status of the applicant, namely Ishan, ESHAN, Narzari, inmate of District Jail, Abhayapuri, and fix a date for the health checkup of the applicant. Next paragraph, on the appointed date and time as fixed by the superintendent of district jail, the superintendent of FA MC, short code, Medical College and Hospital, the superintendent of district jail, Abhayapuri, shall produce the applicant before the medical board. Next paragraph. The medical report of the applicant be produced before this court through the office of the public prosecutor, Assam. Next paragraph. Within 2 weeks, it can be done. You did after 15 days. The 16th. 4th of March.
He will be produced before the board.
No. We are not fixing it. The superintendent of the Fakhruddin Ali Ahmed Medical College and Hospital, they will fix a date. On that appointed date and time, they will be produced before the medical board. And medical report should be presented before the court on 4th of March. So they get 15 clear days time to do it.
Not enough.
Next paragraph, the learned APP shall send a downloaded copy of this order to the superintendent, district jail, Abhayapuri, to enable the superintendent of the jail to do the needful. Medical health report is made a part of the court. Yes.
Item number 20. Lordships, I have some personal difficulty today.
No, these matters will be adjourned if I can't complete the matter.
It's like take time.
Huh.
So my presence can be only for the day or so, some personal difficulty today.
Okay,
On Monday or Tuesday, I've taken the consent of Ms. Chaudhary.
okay.
Matter
Hey,
and.
it will not
for my
go,
friend,
This was the order query.
item
Item
20.
20.
We apologize for the inconvenience.
So,
There is another matter where I was supposed to produce these
which item?
Item 22.
22 of supplementary list. Mr. Majumdar's matter. There I got the information from the report was furnished by the superintendent of the police. He said that it's in Bengali, Lordship can read, I've given the copy. Perhaps he did not find him, he could not find the informant. And so he returned back with a report that he could not be found. He did not serve it on the male member, elder male member of the family.
They may not be there.
There is mother, is that Asmi's part? Oh, it's there, Lordship can see. What I can read, it's in Bengali. So some fast. Manoniyo, Lordship got it?
No.
Oh. Is it Boga? Here you go. He can read it. Manoniyo Mohodaye Adesh for
Okay.
Adesh Patel,
Just we'll do it.
Lordship.
হ্যাঁ, এলাকায় আমার অনেক বেঙ্গলি উল্লেখিত
কি লিখেছে সব?
মাননীয় মহোদয়ের আদেশ মতো উল্লেখিত এলাকায় গিয়ে
হুম।
কিসের নামনীয় মহিলার খবর নিয়ে কোনো সন্ধান পাইলেন। এলাকার লোকজনে জিজ্ঞাসাবাদ করিলে উক্ত মহিলার সঠিক শাখায় কেহ কোনো সন্ধান দিতে পারে কানুনি লেগেছেন তাই এড়িয়ে দিব তারা এই অবস্থায় করিতে যথাস্থান প্রেরণের জন্য রাঙ্গিরকারী টিওকে জমা পাবলিক প্লেস অফ
Public place of display of approval.
যথাস্থানে প্লেস রাঙ্গিরকারী টিওকে
Return করিলেন। খবর নেবেন।
It means that her whereabouts are not known. So what to do in such cases? What to do in such cases?
Then public notice, then has.
No, then we'll appoint an amicus to take care of their interest.
That is a better way, am I?
Okay. For Mr. L.R. Mazumdar, counsel for the applicant dash appellant. We pass separate orders in I and this, this. In I will be applicant, here it will be appellant in the appeal. And Miss, no full stop. Miss S. Jahan and APP has produced a copy of report submitted by the in charge, forwarded by the officer in charge of Silchar Police Station, indicating that the concerned constable named therein, named in the report, could not find the whereabouts of the respondent number 2 at her given place of residence, and accordingly the notice was returned without service. Next para, accordingly, as the whereabouts of respondent number 2 is not known, the court is inclined to appoint the Atal Tiwari as legal aid counsel to represent respondent number 2. Whose name appears in the notification number 120 dated 6/12/2023. As a matter clear the matter to represent respondent number 2. The registry shall contact. Shall inform the amicus curiae and provide him with a photocopy of this. Here you will write interlocutory application and then in appeal memo appeal. Interlocutory appeal, memo appeal. Full stop. List on. '28 to 2024. For consideration of the LCR has come. Yes. List on so and so. We'll consider that on the next date. You please inform Mr. Tiwari if you can find him. Acha. Paper book. That's why in the meanwhile, the registry shall prepare the paper book in terms of order already passed on 24/11/2023. This will be, paper book will be in appeal, not in I.
Not feeling very well, so in with your lordship's permission, I'm leaving. Lordship, we will continue with this and I'm. Lordship.
Item 23 to item 25 to 37.
Should we send you to our medical unit? No. Okay. You're sure not a bahana? Okay. But this is some kind of pandemic. This sore throat, if one has it, this time it is continuing for about a month. I also suffered. It's happening in every home.
I can feel it inside, very heavy. Maybe COVID, some kind of COVID.
No, that is no, it is happening, but we don't have an answer. But it's some sort of infection.
But no, I've been told by a doctor that presently there's some kind of this what you call wave is going on. Either it is some kind of cold or influenza or something is everybody is getting affected too. It is not that singular isolated heart case. But you have to be very. No, you have to be very careful about.
No, you can't save yourself because you see, I feel that I am so distant with everyone. Nobody comes close. We are not in a what you call closed environment. Still, I contracted it. I had suffered COVID twice. Just can't avoid it. Mask doesn't help really. It gives a satisfaction, but I don't think masks.
They should delete people and zero evidence. My lord, accused number 10, accused number 12, 16, 17, and accused number 7.
All similar argument,
It's all similar.
all similar,
because
okay. Accused number
not accused number
7,
10, no, accused number 7 are not, accused number 10,
10,
accused number 10, apart from that evidence, accused number 12, 16, 17 will be more or less similar. Accused number 12, 16, 17.
okay.
These are all from emails, my lord. And accused number 10, apart from that PW force, which I have mentioned, my lord, one, and accused number 7, in addition, PW 7. That is how to
Okay,
set up.
what is their appeal number, accused number 10?
Accused number 10 is detained, my lord.
Oh, that's already over. Huh.
Accused 12, 16, and 17, my lord. I have.
Yes, what is the name of accused 12?
12, 16, M. Evolve, accused number 12. The criminal.
Name, criminal appeal number?
Criminal appeal number, 145 of 2017.
145. Mutum Ibrahim.
Two.
Mutum Ibrahim, you already argued.
And accused number 17, Jatisor. Accused number 17, Jatisor.
Just a moment, there is
Criminal appeal number 299.
299.
These two will be same set of evidence. Same.
Just a moment. Yes,
Accused number, 12 and 17 will be same, 299 and 145 will be same. Now, for accused number 16 and Delhi, which I just mentioned yesterday, my lord, even though he has language whole sentence behind the bar, the only pertinent thing, only one accused number 16, PW7, my lord. PW7, that individual, my lord. I'll just recall, my lord. He said
just a moment.
PW7.
No, just a moment. Number one. He's this Jyotishar Singh. He's convicted under which provision?
20, 121A of IPC. and
Convicted under 20,
18,
120,
20, 18 of UAPA and 121A.
20 and 18 of UAPA. Yes,
121A
A.
of IPC.
okay.
And
He is also completed his sentence and he has been released. Okay,
Yes, sir, about 7.5,
7.5 years.
about. I'll give the exact date. But in Delhi, accused number 16, my lord.
His sentence is how much? Maximum sentence?
In Delhi, 10 years. For
10
all
years.
10 years, for everything except Gandhoni, all 10 years.
10 years.
And in Delhi, was and Delhi accused number 16, my lord.
He was also arrested in Nunmati police station.
Yes, yes. All by Nunmati police station except RK Megan, it is 19. And Dilip Singh, accused number 16,
No, one by one. We are now in Jyotishar Singh.
that is what.
Huh.
Jagdishwar Singh, accused number 17, criminal appeal 299 of
Yes.
2016. And M. Igor Singh, criminal appeal number 145 2017. They were arrested on the same day by the Nunmati police. They were arrested on the same day. Both of them are convicted under 20 and 18 of UFDA and 121.
Yes.
See,
So same sort of evidence, PW 5374.
my lord, 53, 74, 44 will be all same set of evidence.
Okay.
And even Jatisor's photo was found in 205 and 18. The photos were set.
Same set of evidence of PW
12 and 17.
PW 12,
17.
PW 17, PW 44 also.
PW 44, PW 74, they are all experts. PW 53, 74, 44.
No,
they are
no.
experts.
Have they implicated you?
No, 74 and 53, they are the one who retrieve emails.
Okay.
It's all the same. And PW 44 Gangwar who compare the photos, the same thing.
Yes.
But in case of Jatiswar Melon,
Yes.
PW number 74 is it PW 74? PW 74 in case of Jatiswar Melon, what is addition? PW 72 below, in case of Jatiswar. I'm the 72 is the wife of Jatiswar.
72.
72.
His accused number
17.
17. Jyotishwar.
Or Jatiswar. L Jatiswar.
L. Jatishwar Singh. Wife of yes.
She said that Jatiswar wife was here in Guwahati. She was only put this in pros. I'm staying in the address given below by the above.
You're reading where? You're reading which paper book?
Oh, nonsense. Part 1, volume 2.
It's 76.
This is he said, I'm staying in the address given by me in the hour. I am married to L. Jatiswar Singh in the year 2006. He is in the jail in connection with this case. I have seen him in the court today. In the year 2009, I came to Guwahati. They married in 2006. In the year 2000, I came to Guwahati and I was examined in Pratiksha Hospital for gynecology problem. I stayed for a long period for my treatment. During my stay, I used to stay in hotel as well as in hospital for treatment. The experience of treatment and for my stay was borne by my husband and my family members. My husband was doing the business of selling small articles. When I was in hospital for the delivery of my child, I came to know that my husband was arrested. After some time, I came to meet my husband in Central Jail. That's all she said. She didn't say anything about my listing. She said, I'm a small, selling small articles. She was married to me in the year 2006 and 2009, I was arrested. Except this, it's same set of evidence, including emails and the photos, everything.
Small may be anything. Small may be anything. It may be bullet also.
Can be anything. Not serious, right? He has not specified what business, cloth or tea stationery, small business. Or if it is selling a small business, it can be said that it's legally permitted business. That's
Okay, legally permissible. Okay, good. Good.
My lord, so for accused number 16, I have mentioned yesterday also, criminal appeal number 113 of 2017. But so far my information goes, my lord,
Oh, this
113 of 2000.
113 is and Dilip Singh. And Dilip Singh we have already done.
No, I've not that, I just mentioned yesterday
Ah.
that he has completed his sentence. Now, why, even though he has filed a criminal plea, what happened, yesterday I came across with my friend yesterday, that in PW7, Miller, you don't need to take, lordship to that PW7, because lordship is quite aware of the fact. PW7 says, if I'm not wrong, that in China, S16, A20, A18 were there in China. Mr. Thavel, they were in China. That's what as per PW7 says. But again, when I checked in Trivandrum statement, others are that particular question that PW7 says that you were in China, that particular question, I don't know how something, somehow it has been missed. He was not given that opportunity to explain that he was in China. I checked, was said, I didn't find it. At least two him, I didn't find it. That particular person was not good to. That as per PW7, you were in China, that was just cross-checking that. Milord, I
Yeah,
respectfully
just a
said,
moment, just a
Milord,
moment. Yes.
Milord, I respectfully say, Milord, to part one, room 4. Part one, room 4. The relevant page will be, Milord, page 843.
Which page?
Page 843.
843.
Question number 13, 14, and 15 are the relevant questions. 843.
This is for which accused?
Dilip
Hmm?
and Dilip Singh.
And Dilip Singh.
December 13, PW7 individual farm has also deposited A7 Samarjit and Itrozine to you A16 in material. We discussed about business of sending students to China. In December 2000, he given to government with his wife in connection with handloom business and Samarjit S7 inform him that you and your friends are coming like to discuss sending students to China. This is a question he said space. PW7 Universal Program also deposed he and his wife were received by China. From there, went to hotel, we married so and so, and discussed it. PW Universal Program was also deposed that he visited China and there he met Mr. Chen, who took him to the hotel where and Nongyai A18 and met Thabal A20 and one second where in another room where they were talking about the purchase and about military products. And so. So even to delete this pertinent question was not good by the court that you were saying, right? But as per PW 84, that your lordship was pleased to point out that even Samarjit, AQ7, including Didi, was in prayer. But to Samarjit also that particular question was not asked, even to Didi. And my lord, Mr. Noya, accused number A18 have not preferred an appeal. But however, my lord, just as is a matter of record, even this particular question was not put to Noya, the whether Dilip accompanied. Even to Noya, it was not. Well, so far Noya is concerned, my lord, the relevant question will be in page 871.
This is which appellant?
No, he has not preferred an appeal, but even to Noya, that particular question was just for the inference, my lord, just for the sake of inference.
Okay,
Even
which
to
page?
871.
871. Yes, 871.
871, question number 13, it was question to Noya, accused number 18. He has not preferred appeal, my lord. Here also accused number 16 has not come to the picture.
No, we would not find anything here because this is a question put to one accused, reference to other may not be there.
My humble submission is, my lord, the pertinent question was not put to Dilip. Dilip is an appellant. Dilip is an appellant here. So, but however, Noya is not an appellant here. My only humble submission is that even this question was not put to judge just for a reference, my lord. It may not have a binding on another accused. The question that is put to me will have a binding, but not the question put to others. I'm just trying to draw an inference. Even this incriminating question was not put to Mr. Joel, just for my inference. But however, PW, but not IT, Mr. Srivastava, we have denied, but he said Mr. Dilip was there, Samarjit was there, Thabal was there. That's what your lordship pointed out in page 424, my lord, of PW 70. I'm just trying to negate them, my lord. Just to negate them. My lord,
Mr. Singh, you are not being able to follow your argument.
my humble submission is that in one cases, PW's 80, Mr. Srivastava, said that A16 and A7 was in China. Even though that thing has not.
I'll put it in a different way. You see, today we two brothers are in the bench, correct? Now, immediately when we rise at 3:30, you will find my brother going this side to his own chamber and court. He also has a single bench. I also have a single bench. So he's going. And in the corridor, if you, I'm just saying in a lighter tone, you ask me about my brother, that how is brother? I may reply that, well, I don't know. How is my brother? You ask him. I'm not his spokesman. So you see, although we are brothers and sitting together, 5 minutes down the timeline, if you ask me about him, I may give you this strange reply.
I
I don't say I'll do it, but I may give a strange reply. You see, a question asked to someone without referring to X under 313 will not be will not influence the court in respect of other accused.
No, look, my submission was not that in that line. My only humble submission was PW7. PW7 has said that accused number 16, Mr. Dilip, accused number 18, and accused number 20, who is an absconder, were in China. Were in China. That is what PW7 said. Now, PW7 has not mentioned about accused number 7 also, that he was in China. But however, in page 44 of PW18, Mr. Srivastava has roped everybody, including accused number 7, that accused number 7, accused number 16, accused number 18, accused number 20 were in China, and they were trying to procure arms. So far, so far accused A7 is concerned, my lord, that has been clarified from the version of PW7, as well as from the question put to him by the court that he was not in China. That is very clear. That aspect is very clear. Now, that question of A16, even though he has served his term, my lord, it goes acquittal, my lord, it will benefit him also for the future purpose. So accused number 16, my lord, it is said by PW7 that he was in China, and as well as by PW18 that he was in China. Now, that his presence was in China has not been put as a question in 3132 in him, even though that is very incriminating. That incriminating portion to him was not given to explain. I'm just confining to A16. Well, I have just referred A18, not to have a binding on A16, just for an inference, just to bring into your notice of your lordship, even though he is not an appellant, that even a question was not put to him that A16, A18, and A20 were in China. Is it true or false? Even that question was not put. That is only my humble suggestion.
Okay.
My lord, therefore, my lord, so far N. Dilip Singh is concerned, apart from sense set of evidence, my lord, that email and other set of evidence, that is PW7 who has said that about this Kathmandu, about China, my lord. So even though Dilip is there, having not put that incriminating question to him about the stay in China, that cannot be against him, my lord. That's what my submission. Now, totally coming out from all these, my lord, with IBOMSA A25, my lord, criminal appeal number 295 of 2016. And he has been convicted under section 20 and 21. Huh? No, 20 was it? All accused will be all accused will be
Criminal Appeal 295.
My lord.
Criminal Appeal 295.
Yes, 295, 2016.
A.
IBOMSA.
IBOMCHA. Yes.
For A. IBOMSA, my lord, the background is
He is convicted under section
20 and 21.
20 and
21 of UAPA.
In 20 and 21, okay. Yes,
Holding process of repressing terrorists, 21.
he has served his sentence completely,
7 years.
7 years.
He was commissioner, yeah, almost 7 years, yes, sir, almost. But he was arrested in 2011. 2011, maybe about 7 years, not in 2000.
His sentence was 7 years.
7 years before the courts.
His
No.
accused number
Accused number 25,
25. 25.
525.
25, huh.
My lord, before I take the depositions of the witness, my lord,
He's also arrested in the Nurmati PS case.
after NIA has taken over. He'll be Nulmati, but after NIA has taken. Nulmati case was handed over to NIA on 14/9/2010, if I'm not mistaken, my lord. Thereafter, it was registered as 1 of 2010. Thereafter, arrest was made in 2011. So far, he was arrested.
Okay.
My lord, before I take my lord to the evidence part. Now, what is section 21 here? Where I have been convicted? Lord, I am responsible take your lordship to Unlawful Activities Act, section 21.
UAPA.
Section 21. Punishment for holding process of terrorism.
Single bench will have to sit. We'll continue tomorrow.
Oh, good on Monday.
Tomorrow? Tomorrow is a working day.
Sir has got some Saturday problem. That's why sir was telling me. Monday.
Monday.
Subject to your lordship.
So far I'm concerned, my lord, I'm ready. My lord,
Mr. Das,
I'll come to my.
can we do one thing? We'll we'll allow Mr. Singh to complete his part, and then your part will do it on Monday. Will it be will it be okay with you? She'll be here to, she can take notes or can take notes. The submissions of Mr. N.G. Singh, learned counsel for the appellants in criminal appeal 295 of 2016 remains inconclusive. List as a part matter on, sorry, just say, Mr. D.K. Das, senior counsel, assisted by Mr. G. Bharadwaj, D. Bharadwaj, counsel for NIA, and Ms. L. Devi, learned counsel appearing on behalf of the learned DIGI is present for respondent number 1. List tomorrow, you demonstrate as a pattern matter. You just remind me tomorrow, we'll adjourn your part to Monday. Tomorrow, remind me, your assisting council can remind us. We'll fix it on Monday for you.
Yeah, PV Lordship, it's my humble prayer before you, or regarding item number 21, can it be taken up on 23rd of February, my lord?
All those matters will.
Much obliged.
phone এটা করে দিও নিছি
You're there?
We have to come after something.
After some time. Yes. Yeah, matter. Could not be retrieved.
From Mr. Bhattacharya, he said he was on legs in group number 17.
Okay, after some time. Okay.
Sir, item 1 FC Kelsa.
Thank you.
Yes, sir, now.
I'm sorry, Lordship, I was engaging.
Wait, Peter, Lordship.
Yes.
My lord, this is a bail application, my lord. The petitioner is under trial, my lord. Trial is going on and PW1 is examined. PW2 came, my lord, but could not be examined for some technical reasons. So PW1, perhaps PW1's deposition is before your lordship. I only leave it on the incident. He was the informant, my lord. So I only leave it upon the PW's deposition, my lord. Lordship may go through when my whatever my lord role can be, I think it can be revealed, my lord. He's in custody for 425 days.
400.
25 days. How many custody, my lord? It is in the law.
What is the quantity of drugs seized
My lord, released for us.
commercially? What was seized? How much quantity?
153.2 kg of ganja,
1,
153.2
2 kg.
ganja,
Yes.
179 gram of methamphetamine tablet. And lordship, 1.020 kgs of brown color substance suspected to be heroin,
How much?
1.020 kg. 1 kg, 20 gram. Then lordship, 16 bottles of Andrex cough syrup, codeine based,
16 bottles of
codeine based cough syrup. To ganja lordship, more than 20 kg is commercial, and methamphetamine tablet 50 grams, the minimum quantity.
methamphetamine is how much?
50 grams.
50 grams. And heroin?
Lordship, 2.250. 250.
250 grams.
Cough syrup is 1 kg.
1 kg.
Okay, it is a must. But it will not be fall under, 16 bottle will not fall under.
But this, he spent 425 days in custody. Why we should not release him now?
Sip, just to see. The quantity is commercial quantity, everything is. Then lordship, charge sheet was filed on 14/6/2023.
14,
14/6/2023.
623.
And one witness was examined in the month of January 24.
Yes.
The lordship, total witness proceeded is not reflected. On 8/2/24 case was fixed, but even though lordship, the witness was present, but he could not be examined. He was not examined on that day.
The lady officer came down, my lord, I was on the other side, she came, my lord, but due to non-serving of a copy, that our scientific report, my lord, the PW could not be paid. But my lord, PW one, if your lordship goes to, my lord.
Lordship,
No, is it letting for me? He's trying to show something.
My lord, I just wanted to show that PW one statement.
Yes, yes,
That is before lordship.
yes.
My lord, lordship will find because they are, this, the place of occurrence, my lord, at the time of recovery, my lord, and recovered items, when at that point of time, this particular item was not present. My lord will see another module was present, that from the informants, my lord, thorough deposition, my lord, Atikur's name nowhere appears, my lord. Only it comes that he, as a driver, he came along with that particular another accused.
At the time of seizure.
Time of seizure, and when the police, when the NCB personnel, my lord, have raided the place, my lord, that particular place of occurrence, that is the house was a railway quarter, my lord. And all these elements were found there. And one module was found to be the custodian of those things, my lord. And he said, my lord, he was in behalf of Jitul Ali. Also will find it in PW1, my lord. But nothing was implemented, that implications were against this particular account, my lord.
Okay.
That is my submission.
Yes.
Lordship, may come to page 17. The search comes easier, please.
Page 17 of
Benefits.
bill application.
Documentary to see, item number 1 to 3 and 4. These are the substances which are recovered. 153.2 kg of ganja. WY tablets 179 gram. Then brown color substance 1.020 kgs. Then Lordship, 16 bottles of item number 7. Lordship, below, Lordship, please to see. There is a signature of 3 persons. One is Jitul Ali, 2 is Moinul Islam, then Atikur Rahman petitioner.
Yes.
Then Lordship, may come to page 18, where is a real application was rejected. Lordship may come to page 19. Second paragraph. Married. As per seizure list, so and so, the quantity is mentioned. And with one magazine as well as 2 vehicles were seized from Jitul Ali. Investigators revealed that the petitioner was earlier working as home guard, and as per the investigation carried out so far, he also used to drive the seized vehicles of Jitul Ali. And there are sufficient materials to show that the petitioner is involved in drug trafficking. Lordship, in instruction, Lordship, in complaint petition, the role of the petitioner has been, what materials has been seized. But it is role, that is the difference in the complaint petition, although it is not before your Lordship.
Yes.
And Lordship, further, it cannot be said that the trial has been delayed, Lordship, because Lordship is saying that the complaint was filed on 14/6. One witness has already been examined. And Lordship, how many witnesses are there, Lordship? I'm not able to give the total numbers of witnesses cited by the, because complaint is not before me. And Lordship, one witness was examined, second was not examined. I think my learned friend submitted that due to some technical reason. Also,
Total number of 13 witnesses. My lord, again, I just want to point out one thing, my lord. The original, that report, my lord, on basis of which the raid was conducted now. First, this was brought down in written. That is at page 12, my lord. This is report in my page 12.
Yes.
Yes, my lord, will see down below, list of information recorded. List of information.
Yes.
Yes. On dated this and this at around 21 hours, I received an information from a reliable source that there is a house at the address of this and this railway colony. Taminggaon, and Jitul Ali is the owner of the house, and he stored a huge quantity of ganja, W tablets, brown sugar, and cough syrup there. He he carries gun also. Jitul Ali, Jitul Ali used Monirul Islam at the same house as a caretaker. And Moinul Islam also worked as a driver of Jitul Ali. Here, my lord, my client's name was not there. That must have been so.
Okay, we'll go through it. in procedures.
Actually, this is only a first information, secret information. Thereafter, Lordship search was made. And Lordship, this is the copy of my landed pen. Lordship allow him to read the role of the present petitioner. Lordship may please to present this. With the permission of my landed pen, can I copy the copy? Yes, yes, of course. Paragraph 94 to 101. These are the role of the present petitioner discovered during the investigation. And out of 12 witness, what if we have cited 12 witness, 13 is any other witness? Out of 12, one is examined. Lordship, recently we got information, 3 witnesses been examined. First on 9/12, second on 11/1.
No. I was there in the trial. So, no. First, one was, 2 accused didn't cross-examine, so again the information was called for. Not on a second.
My colleague has just.
I was referring on the dates, man.
He has written 9/12, 11/1, 8/2, 2024.
Yes. This
Yeah,
is-
but
this
we'll
is
accept
my-
the statement of Mr. Hazarika.
Yes. Why not? Because 2 of the accused person was.
No, we accept your statement, no problem with that.
So this is the role of the present petitioner.
We have not found Mr. Hazarika, we do not believable.
Well, let's say that check up from the IO.
That's okay. But he'll know because if he's in the trial court, he will know more.
Because there are 3 accused, my lord. 2 accused was represented by some other advocates. He was not present. That is why I didn't call for. So, this case I denied basically on the PW1, my lord. Because it's the informant. And he has elaborately cited the story, my lord. So these things are prior to PW1, my lord.
Yes, yeah.
Coupled with the materials available on the record, what's the rigors of the 37 big also applicable here. And what we recently, earlier I also cited for Lordship, although this matter, the case is related to UPI. In paragraph 32, Honorable Supreme Court has stated, therefore, I'm reading 3 lines. Therefore, mere delay in trial pertaining to grave offense as one involved in the instant case cannot be used as a ground to grant bail. Hence, the aforesaid argument on the behalf of the appellant cannot be accepted. Based on this, Lordship has passed one order judgment on 29/24 and recently on 13/24. This one considering all the judgments. Even though my learned was not argued that delaying the trial, that has been considered and rigors of section 37 will be also be applicable. I'm placing this judgment for consideration. To so my humble submission of this.
We'll examine and pass orders in these papers. Mr. Hazarika, you may find the order uploaded only tomorrow. So today it may not be possible to upload the orders. You have this paperwork, please take it. Right.
Item 2. Oh, sorry.
It's coming.
Election code number 17. Lordship, the matter has been dragging for such a long time. Lordship, we have tried to trace up the records and after shifting from Kasai to Kangarwadi, they have said that they destroyed most of the records which are older than 15 years. Since this is actually this released in 2007, so no records exist for that particular case.
Then we will not be able to recall the order of pay compensation.
Otherwise, we have next that particular letter. This is the department under whom the petitioner was working. So 18/8/2007. Within 1 month only we intimated them. Now they are saying the finance department is saying that we have not received the letter. But they have received the letter which is of 2015. So in my humble submission, Your Lordship, these are responsible officers. If one government office says that we have sent and another government office says that we have not received, then that puts everyone in a dilemma here. I'm not saying as a lawyer, but as an officer of the court, Your Lordship.
But things may happen, we don't know. Because I don't think Mr. Bhattacharya can also improve it because of the fact that there is already a letter on record saying that the records can't be traced. Hmm? Hmm. Because of administrative side, you'll have to take steps. If this small matters, if it's not communicated, if it is lying in your office otherwise also, you send information to other people. Because people are coming to court after 10 years, 15 years, just because they don't have information. And you see, the presumption is that they have not received it because otherwise after 10 years, why they will come to court?
Worship, also, if I may submit your worship, the, in terms of the very recent judgment of the Honorable Supreme Court in Devabhat Tiwari, therein, the Honorable Supreme Court said that, yes, delay might occur either due to the fault of the petitioner in not approaching the court in time, or on the part of the department are not communicating. But the very essence of this particular compassionate appointment is taken off the endless compassion for that matter. And in my humble submission, your lordship, the petitioner had all the means to file a RTI request also. RTI application seeking the outcome of the DLC meeting. But he decided to be silent for around 10 years. your lordship. Take that
Do you have a count of writ petitions pending in the court where because of non-submission of, non-furnishing of RTI, people have come to writ court instead of going in appeal? Do you have a count?
This is submission, your lordship.
There are plenty of cases where people don't get the information, the required information is truncated. Not one, we have dealt with so many matters. I think we'll close it. May not alter the compensation.
Lordship, if I may suggest, the lordship may kindly lower down the compensation amount. Or, your lordship may kindly lower down the compensation amount because, and also that both the departments share, because now we are in a very just a position. Because we are saying that this particular letter was communicated and they are denying it. Ultimately,
I was thinking otherwise, I should have added some interest for 3 years, not being paid to the petitioner.
no, your lordship, ultimately, it's nobody's fault because our department, the BC office is saying that we have communicated. And, but we don't have any record of that. And we had the record. and we had the-
register or
Dispatch
something also.
also.
Some other postal receipt or some dispatch register.
No, you
That
see,
is not an explanation.
no, you see, we are not, for the time being, when Mr. Bora is making a submission, we are not doubting you. Neither we are doubting you. Maybe communications may have taken place, we don't know. But in the actions, we can't return a finding. The problem is there. It's not that I'm not disbelieving you. For a moment, I'm not saying that we are disbelieving you. Okay, let me examine and pass orders. Examine pass orders. Maybe you'll get the orders uploaded on Monday.